she's supposed to be here in person.
Yeah, I thought so.
In custody Zoom 1 p.m.
Both of them. Right? I mean,
You
that's
could-
what he said. I heard that I'm supposed to be here in person down here, and I don't have it.
I don't know, but if the PDO is not on pretty quick, they're gonna lose their person status because of county. Because they're not on yet, and I'm not gonna, what in the heck is up here on the screen? I'm trying to get back to my. There we go. Yeah, I couldn't get it off of the YouTube.
Hey, man, you're gonna end up getting going in the chair, man, keep yelling.
Judge, at some point, I have
I got Zooms going on right now, man.
Go ahead,
I have
Cheryl.
some new information that I got this morning that I need to discuss with my client. So if I could, at some point, have a brief moment with her in a breakout room.
Okay, put it in the chair.
Oh, you don't have any idea how complicated that gets, Cheryl.
I am very sorry. I tried to call and hope that she would call back,
You get a prison, man.
but I never received a call back.
Hold it.
Yeah, the only way I have to do that is shut down the whole hearing. So bear with me. We'll try to get to her in a little bit.
Well, and it just as an FYI, I also have Zoom court with Judge Hoffman at 1:30. So
He's already sitting here right on it, yeah.
if I disappear, I'll be back.
Okay. I still don't see the PDO. We'll give them a couple more minutes and then we'll move on.
That's what I told him.
Daniel, I'm assuming you already know this, but I think your client was indicted yesterday.
On Mr. Alberto?
I believe that's the name.
No,
Yes.
okay. What will that do for my writ? Will that do anything for the writ file?
As far as the writ goes, it makes the writ go away, but I mean, you can still
Okay.
try to pursue a reduction in bond if you want to.
Through a motion?
Why don't you put yourself on mute and give the DA's office a call and see what y'all want to do with it.
Okay, thank you.
Sure. I still don't see the PDO. Well, we're gonna have to. I was trying to get Atascosa County in and out.
Miguel just signed on.
Not on my computer.
Your Honor, we have to put.
Oh, there he is. Okay. Yeah, we're gonna start out with Ms. Lockhart so we can get Atascosa off the line.
Yeah. Oh, thanks.
Now the microphone is on. You can turn it off if you want.
Ms. Lockhart, can you hear us okay?
Yes, sir.
Great, thank you. Do you know if we have a waiver of appearance by telephonic hearing on Ms. Lockhart? Because I'm
Yes,
not.
Judge, we should have submitted that with the plea paperwork this morning.
One for all of them. So it might be on that side.
There it is. That's okay. As long as we have one, we're good.
Want to pick those up? Because you're on the meeting, okay?
Paul, you ready? Court will call cause number B20-448 and 550, B21, 448, 559, and 560. The state of Texas versus Dana Lockhart for purposes of agreed pleas. What say the parties?
State's ready.
Defense is ready, Judge.
First document we need to go through is the joint request for plea or sentencing by video conference. Ms. Lockhart, it purports to have your signature.
Yes,
Is
sir.
that your signature?
Yes, sir.
Do you have any objection to appearing by video conference today?
No, sir.
Thank you. Sorry, Paul, I'm trying not to hit your mic over here. Cause numbers B2448 and 550, and then B21-448. Looks like we have agreed pleas in each of those three cases. First document we need to go through in each one is the 3914 Discovery Disclosure and Compliance Form, which purports to have each of your signatures, counsel. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
To the best of your knowledge, has the state received all the discovery in all three cases and forwarded the same to the defense?
Yes, sir.
To the best of your knowledge, have you received all the discovery in all three cases?
Yes, Your Honor.
Is there any objection to going through the admonishments together?
No, sir.
No objection.
Ms. Lockhart, I'm going to show you one document, but in fact, there's three. Each of them titled Defendant's Plea of Guilty, Waivers, and Admonishment. Did you have a chance to go through all three of those documents with your attorney?
Yes, sir.
Did you understand all three of those documents?
Yes, sir.
Do you understand in all three cases you have a right to a trial by jury?
Yes, sir.
Do you understand in all three cases you have the right for your attorney to cross-examine the state's witnesses and to call your own witness?
Yes,
And
sir.
do you understand that you have a right to appeal?
Yes, sir.
Do you understand that you're waiving all three of those rights in all three cases today?
Yes, sir.
In addition to that, do you understand that you have a right to remain silent? Nobody can require you to testify against yourself, but you can in fact waive that right.
Yes, sir.
Page 3 of each of these documents purports to have your signature in different locations.
Yes,
Do you
sir.
recall signing each of these documents in two spots on page 3?
Yes, sir.
Your second signature in each one appears below a paragraph entitled Judicial Confessions and Stipulations. You understand that by signing this paragraph, it's just like you stood up before the court, raised your hand and said, I did what the state's accused me of doing.
Yes, sir.
Attached to the back of each one of these is a copy of the grand jury indictment for each case. Each one of them purports to have your signature on the bottom. Do you recall signing all three indictments?
Yes, sir.
And are you asking the court to accept as true and correct all three grand jury indictments?
Yes, sir.
You feel like your client understands our rights, waivers, and admonishments in all three cases?
I do, Your Honor.
How do you say it? It's Chancellor. It's Chancellor. Yes.
If you won't see the judge till tomorrow, when you see the judge, he'll set your bond, either give you a PR or a surety bond. So you won't be seeing them tomorrow till tomorrow. You'll have to stay overnight for sure.
Ms. Lockhart, in cause number B20-448, you've been charged with tampering with physical evidence. This is a third-degree felony. The range of punishment of 2 to 10 years incarceration and up to a $10,000 fine. Do you understand this charge and this range of punishment?
Yes,
So
sir.
no withdrawal.
And how do you plead?
Each of them had a brain injury.
Guilty.
Have you ever
Right.
attempted suicide?
I can't answer right or wrong. That's a decision you have to make.
Yes, guilty.
Do you have a flashback nightmare?
Cause number B20-550, you've been charged with possession of a controlled substance, to wit methamphetamine, from 4 to 200 grams.
What
This is a second-degree felony with a range of punishment of 2 to 20 years incarceration and up to a $10,000 fine. Do you understand this charge and this range of punishment?
Yes, sir.
And how do you plead to this case?
Guilty.
Chancellor.
Cause number B21-448, you've been charged with possession of a controlled substance, to wit methamphetamine less than 1 gram. This is a state jail felony with a range of punishment of 6 months to 2 years confinement and up to a $10,000 fine. Do you understand this charge and this range of punishment?
Yes, sir.
What hospital or
And
what-
how do you plead?
Guilty.
In all 3 of these cases, are you pleading guilty freely and voluntarily?
Yes, sir.
In all 3 of these cases, are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And are you a citizen of the United States?
Yes, sir.
Do you feel like your client's competent and capable of assisting you in preparation for trial on all 3 cases?
You just
Yes,
have-
Your Honor, I do.
Are there plea agreements in all 3?
Yes, Your Honor. In B20, well, actually, Judge, in all 3 cases, it's 5 years deferred adjudication. And then in B2448, there's no early termination, drug and alcohol treatment approved by the probation department, and completion of life skills. In B20550, there's a $2,500 fine, $180 in restitution. Also no early termination, drug and alcohol treatment approved by the probation department, and completion of life skills. And then in B20448, there is $180 in restitution. Also, no early termination, drug and alcohol treatment approved by the probation department, and completion of life skills. In addition to that, as part of the plea bargain, we have before the court 2 motions to dismiss, one for B21559 and the other one for B21560.
Tiger, is that your understanding of all 5 of those agreements?
It is, Your Honor.
Ms. Lockhart, is that your understanding of each of the plea agreements?
Yes, sir.
Anyone in court?
Okay, let's talk about deferred adjudication in 448, 550, and then 448 again. Do you understand that deferred adjudication is like a 2-sided coin? If you successfully complete all the terms and conditions of probation, not only do you not have a final conviction, but you may be entitled to file a motion for non-disclosure. Do you understand that?
Yes, sir.
Do you understand the flip side of the coin? If you violate your terms and conditions of probation on any of these 3 cases, you're subject to the full range of punishment on each of these cases. Do you understand that?
Yes, sir.
In addition to that, do you understand that a plea agreement is an agreement between you and the state? It's not binding on the court, but if the court did not accept your plea agreements, you would have the opportunity to withdraw your pleas of guilty, enter pleas of not guilty, and proceed to trial.
Yes, sir.
And are you asking the court to follow each of these plea agreements?
Yes, sir.
Excuse me, real quick.
Jimmy?
Cause number B20-448, B2550, and B21-448. In all 3 cases, court will find evidence beyond a reasonable doubt to enter a finding of guilt. In all 3 cases, will defer any such finding of guilt for a period of 5 years. In 448, there's an understanding that there will not be any early termination of probation. You must successfully complete a drug and alcohol treatment program approved by the probation department. You must successfully complete the life skills class. You have cost in the amount of $290 and reimbursement fees in the amount of $85. And B2550, you have a fine in the amount of $2,500, restitution in the amount of $180. Once again, there's no early termination, and you must successfully complete life skills and a drug and alcohol treatment program. You have court cost in the amount of $290, and you have reimbursement fees in the amount of $715. B21-448. You have $180 restitution. Once again, no early termination. Must successfully complete a drug and alcohol treatment program and the life skills program. You have court costs in the amount of $290 and reimbursement fees in the amount of $290. Do you have any questions on any of these three judgments?
No, sir.
Attached to the back of all three of these orders is an order granting community supervision.
Yes, sir.
Do you recall going through those orders with your attorney?
Sir?
You remember going through those orders with your attorney?
Yes, I do.
Did you understand those orders?
Yes.
Do you understand those orders contain all the terms and conditions of probation?
Yes, sir.
You understand your terms and conditions of probation include a $60 per month probation fee? There's three cases, but there's only one fee, okay?
Okay.
You understand that all three of the cases carry a one-time $50 Crime Stoppers fee that's due within 6 months.
Yes, sir.
Do you understand you're subject to random urinalysis and drug tests at your own expense?
Yes, sir.
Do you understand that you're agreeing to a search of your person, your place, your residence, your vehicle, or any electronics to ensure conformance with the terms and conditions of probation?
Yes, sir.
Do you understand you must successfully complete the life skills program?
Yes, sir. I started that
understand?
already.
Good. That's very good. And do you understand that you must successfully complete a drug and alcohol treatment program if ordered to do so by probation?
Yes, that they would tell me, they would assess me and then tell me what they needed me to do.
Yes, ma'am.
Yes, sir.
Yeah. Depending on your assessment, will determine what level of treatment.
Okay. Yes, sir.
What do you have holding you in Atascosa County?
Charges from 2019, possession under a gram and one to four, I believe. And they're from 2019. They were waiting for me to sign with you before they would offer me probation. So I've been waiting basically to go back to Kerr County. And then, of course, the COVID and stuff didn't permit that. But so basically, they're waiting for me to sign probation with you, and then they would offer me probation here
Okay. Where are you planning on living once you're discharged from there?
in Kerr County.
I'm only going to give you community service in one case. In cause number B20-5050, you have 200 hours of community service. I'm not going to give you any in the other cases.
Okay.
Frankly, I think it's more important that you work on getting yourself back on the right track and get
Yes,
all
sir.
your costs and fees paid off, okay?
Yes, sir. That would be my main.
Do you have any questions?
Okay, it's not going, me signing over here in Atascosa County is not in any way going to affect my Kerr County charge plea?
No, ma'am.
Okay, I'm just really concerned, like, I don't want them to get that mixed up and then me get in trouble, you know?
No, you're not going to get revoked in Kerr County because you signed a plea agreement in Atascosa, okay?
Okay, I was just making sure. Thank you, sir.
Now, that being said, you need to understand that if you pick up a new charge in Atascosa, that's a whole different
Oh,
ballgame.
no. I'm going home to Kerr County. I have no desire to pick up charges anywhere.
Okay,
My only desire is to get back. I have my son Dalton. I don't know if you remember, but he attempted suicide in August and he had to have his leg amputated. I had COVID during that time and I have not even got to see my son in person this entire time. Because right after that, I went to court and came to jail. So my main thing is to go home and take care of that child.
good. Well, I certainly wish you the very best. And we'll see you back in Kerr County.
Yes, sir.
Thank you, Ms. Lockhart. And will you please ask the Atascosa officer to step on the screen for just a minute?
Yes, sir.
All right, you have a seat right there.
Yes, sir.
Hey, I just want to tell you all, thank you very much for accommodating us and working with us on our court today.
Yes, sir, of course.
We appreciate it.
Yes, sir.
Have a good day. Thank you.
You as well, Judge.
Thank you. All right, if you can hear me in Kerr, as soon as I get through signing all these documents, we will start with the guys and just run down them in order. That'll make it easier for you.
Yes, sir.
Depends on what it is. If it's motions, then probably. Okay.
Like, really? This one we got me.
I run out the door.
Where's your mask? Can you make sure your other cameras have
Looks like there's pleas in here. Yeah,
Judge, Mr. Allen's set for pleas today. It says motions, but it's 2 pleas.
I saw that. That's what I just figured out. Give me just 1 second. No, it's not your fault. This is easy. You ready, Paul? Court will call cause number B20-611 and B21-731. The state of Texas versus Dylan Ray Allen. For purposes of agreed pleas, what say the parties?
State's ready. State's ready.
First document we need to go through is the joint request for plea or sentencing by video conference. Reports to have everybody's signature. Mr. Allen, do you have any objection to proceeding today by video conference?
No, sir.
Thank you. The next document we need to go through is the 3914 Discovery Disclosure and Compliance Form in each of these cases, each of which purports to have each of the signatures. Is that correct?
Yes, Your Honor.
Yes, Judge.
To the best of your knowledge, has the state received all discovery from law enforcement, reported the same to the defense?
Yes, sir.
To the best of your knowledge, have you received all discovery?
We have, Judge.
Any objection to going through the admonishments together?
No objection.
No objection.
Mr. Allen, I'm showing you a document entitled Defendant's Plea of Guilty, Waivers, and Admonishments. There's one in each case. Did you have a chance to go through both documents with your attorney?
Yes, sir.
Did you understand both documents?
Yes, sir.
Do you understand in each case you have a right to a trial by jury?
Yes, sir.
Do you understand in each case you have the right for your attorney to cross-examine the state's witnesses and to call your own witnesses?
Yes, sir.
And do you understand in each case you have a right to appeal?
Yes, sir.
Do you understand that you're waiving all 3 of those rights in both cases today?
Yes, sir.
In addition to that, do you understand that you have a right to remain silent? Nobody can require you to testify against yourself, but you can in fact waive that right.
Yes, sir.
On page 3 of each of these documents, it purports to have your signature in 2 different locations. Is that your signature in both spots?
Yes, sir.
Your second signature appears below a paragraph entitled Judicial Confessions and Stipulations. You understand that by signing that paragraph, it's just like you stood up here before the court, raised your hand and said, I did what the state's accused me of doing.
Yes, sir.
Attached to the back of each of these documents is a copy of the grand jury indictment. In B-21-731, it's as originally presented, and in B-2611, it's been amended. On each of these indictments, it purports that
Judge, when you put the paper up, it covered up. We couldn't hear you.
Mr. Allen, do you recall signing both grand jury indictments?
Yes, sir.
And are you asking the court to accept as true and correct both grand jury indictments?
Yes, sir.
In cause number B-20-611, you've been charged with obstruction or retaliation. This is a third-degree felony with a range of punishment of 2 to 10 years incarceration and up to a $10,000 fine. Do you understand this charge and this range of punishment?
Yes, sir.
And how do you plead?
Guilty.
In cause number B-21-731, you've been charged with assault, family violence, and impeding breathing. This is also a third-degree felony with a range of punishment of 2 to 10 years incarceration and up to a $10,000 fine. Do you understand this charge and this range of punishment?
Yes, sir.
And how do you plead?
Guilty.
In both cases, are you pleading guilty freely and voluntarily?
Yes, sir.
In both cases, are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And are you a citizen of the United States?
Yes, sir.
You feel like your client's competent and capable of assisting you in preparation for trial in both cases?
I do, Your Honor.
Are there plea agreements?
Yes, Your Honor. In B-2611, 10 years deferred adjudication, forfeit guns to the district attorney's office. And those guns are a Kimber 911 Custom 2, serial numbers on the judgment, and an SCCY CPX-2 serial number is on the judgment. Then to complete drug and alcohol treatment approved by the probation department. And then in B-21-731, 10 years deferred adjudication, no early termination, a $5,000 fine that can be paid out over the 10 years, comply with the MR assessment and treatment, complete the BIPP program, participate in cognitive thinking classes, drug and alcohol treatment approved by the probation department, and no assaultive, harmful, or threatening contact with the victim.
Mr. Hurd, is that your understanding of both plea agreements?
It is, Your Honor.
Mr. Allen, is that your understanding of both plea agreements?
Yes, sir.
Okay, let's talk about deferred adjudication for a moment. Do you understand deferred adjudication is like a two-sided coin? If you successfully complete all the terms and conditions of probation, not only do you not have a final conviction, but you may be entitled to file a motion for non-disclosure.
Yes, sir.
In addition to that, or do you understand the flip side of the coin, which is if you violate your terms and conditions of probation, you're subject to the full range of punishment on both these offenses?
Yes, sir.
And do you understand that plea agreements are agreements between you and the state? They're not binding on the court, but if the court did not accept either one of your plea agreements, you would have the opportunity to withdraw your pleas of guilty, enter pleas of not guilty, and proceed to trial.
Yes, sir.
And are you asking the court to follow both plea agreements?
Yes, sir.
Cause number B-2611 and B-21-731, court will find evidence beyond a reasonable doubt to enter a finding of guilt. Pursuant to your plea agreement, will defer any such finding of guilt for a period of 10 years. There's no early termination of your probation. In B-2611, you're agreeing to forfeit the 2 guns previously mentioned to the DA's office. There's a drug and alcohol treatment program that's required if mandated by the probation department. In B21-731, in addition to those conditions, you're required to comply with any MHMR assessment and treatment plan. You must successfully complete the Batter's Intervention and Prevention course, the Cognitive Thinking course, and a drug and alcohol treatment program if ordered by probation. And lastly, there's no assaultive, harmful, or threatening contact with the victim of any kind. You have court costs in each case in the amount of $290, and you have reimbursement fees in each case in the amount of $85. Do you have any questions on either one of these judgments?
I spoke with my attorney about it, but I just want to make sure that we were going to deal with the Kimber 1911 was not mine and that the owner was going to be able to pick that up.
That's correct, Judge. We did talk about that. The owner of that firearm does not belong to Mr. Allen. There is a question whether or not he can forfeit that. He doesn't claim he owns it. He is requesting that the owner be allowed to retrieve that firearm.
I think the heart of the agreement is that I guess the gun was in his possession, and we're wanting to make sure that he is no longer going to argue that he has any possessory interest in that gun. To the extent that it's turned over to our office and the owner is able to somehow show that he's the owner of that, the alleged owner is the owner of that gun, we'll work with that person to, if they're the owner then, and they're going to be willing to take custody, then we'll work with them on that.
Does that answer your question?
Yes, sir.
Okay, do you have any more questions?
No, sir.
Attached to the back of each one of these judgments is an order granting community supervision. Did you have a chance to go through each of those documents with your attorney?
Yes, sir.
Did you understand those documents?
Yes, sir.
Do you understand those documents contain all your terms and conditions of probation?
Yes, sir.
Do you understand your terms and conditions of probation include a $60 per month probation fee?
Yes, sir.
2 cases, but there's only 1 fee, okay?
Yes, sir.
Do you understand that each case carries a one-time $50 Crime Stoppers fee that's due within 6 months?
Yes, sir.
Do you understand that you're subject to random urinalysis and drug tests at your own expense?
Yes, sir.
Do you understand that you're agreeing to a search of your person, your place, your residence, your vehicle, or any electronics to ensure conformance with the terms and conditions of probation?
Yes, sir.
Do you understand you must successfully complete a drug and alcohol treatment program if ordered to do so by probation?
Yes, sir.
Do you understand you must successfully complete the cognitive education program?
Yes, sir.
Do you understand you must successfully complete the Batter's Intervention and Prevention program?
Yes, sir.
And do you understand that you need to take an MHMR assessment and follow whatever treatment plan they recommend?
Yes, sir.
And lastly, do you understand that you cannot have any harmful or threatening contact with the victim?
Yes, sir.
Do you have any questions at all on your terms and conditions of probation?
No, sir.
Where do you plan on working when you're discharged?
I'm a contractor. So I work all over the place.
General contracting or?
Yes, sir.
Well, you should be a busy man.
Pretty busy.
All your community service is going to be in one case, which will be B21-731. You have 200 hours of community service. Work with the probation department so they can work around your other obligations, okay?
Yes, sir.
You have any questions?
No, sir.
All right, good luck to you, Mr. Allen.
Thank you.
All right, further, may I be excused?
Absolutely. Thank you.
Yep, y'all have a good day. Thank you.
I missed some stuff. That's pretty much the fallback. Oh, thanks for asking. Mhm. We haven't followed Mr. Alberto yet. I know he just got indicted, but I don't know if the files are set up. Okay. I'll wing it. There's no way you have a file because I just Amber just got all those indictments every hour and a half, 2 hours ago. Yeah. Okay. Okay. And I'll be 21,535 if you want to go ahead and pull the full paperwork out. We'll go with that. Thanks. Can you give me your name, sir?
Caleb Burris.
I'm sorry.
Caleb Burris.
All right, Mr. Burris, it looks like your case was reset to February 23rd.
Okay.
So we'll see you back then, and you should hear from your attorney, okay?
Yes, sir.
Judge, what was the date?
February 23rd.
February 23rd. And hang on real quick before you grab the next one. Stephen, do we still need to bring Mr. Alberto out?
I don't know, Judge. I haven't heard from Mr. Rodriguez, so I don't know what he's got going on.
I was chatting with, or I chatted Ben. I didn't receive a response in the private chat area. I was a little bit confused, Judge, by what you had said. Are you saying that we cannot have a writ hearing on him because he's indicted now?
Well, if the basis, I don't have your files, okay? Because we don't have your files yet, but if the basis of your writ is that he had not been released on bond and he had not been indicted yet, well, now he's been indicted.
I guess it was a writ of habeas corpus, an application for reduction in bond.
Okay. Well,
So,
no, we'll work off the indictment.
okay.
So let's bring out Mr. Alberto, please.
Yes, sir.
Sorry, Daniel, I'm running in the dark a little bit.
Okay.
The bond, for what it's worth, I don't know if you even have this, the bond that was set on each of the counts is $50,000 surety per count.
Yes, I know that.
Okay.
And it's 7 counts, I believe.
6.
6 counts. So 300,000 total.
Yes, sir.
Okay.
Mr. Alberto, can you hear us okay?
Yes, sir.
Thank you. Am I pronouncing your last name correctly?
Yes, sir.
I don't know what the cause number is, but is that it? Is that on one? Okay. Okay. Court will call cause number B-2205, State of Texas versus Anthony Alberto for purposes of a motion to reduce bond and writ of habeas. What say the parties?
Thanks, Freddie.
Defense is ready,
Mr. Rodriguez?
I believe. Your Honor, I should have his father in the waiting room.
The only person I have in a waiting room is somebody on Jason's iPhone.
Okay, he was here. I think he might have had to go back to work because I told him to log on at 1. So he might have excused himself. Let me just text him really quick. See if he can get back on.
And ask him what his identifier is if it's not in his name.
Okay. I'm gonna mute myself for just 2 seconds.
Sure.
That's him on the iPad.
Okay. He was admitted, so let's.
Okay.
If you have one, and if you don't worry about it. I'll scribble them on the back and you can transfer them.
It looks like he's logged on. I just don't see his face. Jason, can you hear us?
Yeah, me?
Yes. We cannot see your face, or can you face towards the camera?
Yeah, I didn't understand any of that, did you? Got there. Okay. Do you have any other witnesses we can talk to while he's trying to get logged in?
No, that's the only one, Your Honor. And it looks like he's fallen off the screen. He's back on. Jason, you need to turn your camera on and make sure it's facing at you. There we go. Can you unmute yourself, Jason?
Yes, can you hear me?
Yes.
All right. Can you please raise your right hand?
I think they're your witness.
I think there might be some lag time here, Judge.
He's either frozen or he's gone.
Yeah. Is there, I guess, when would be the next available date for contested hearing?
February 23rd.
It's kind of a long way.
Can I see if I can step outside in your signal?
Jason, I think that's good enough right there. We seem to be able to see you fine.
Okay,
Going on mute
perfect.
yourself. Okay.
All right. Can you hear me now?
Yes, sir.
Will you please raise your right hand? In the matter before the court, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Can you please give your full name to the court reporter?
Jason Albiter.
Thank you. May proceed.
Thank you. Would you spell your last name for the record?
Yes, Albiter.
Okay. And do you know Anthony Albiter?
Yes, he is my brother.
Okay. And do you see him on the Zoom screen?
No, I cannot see him on the Zoom screen.
Okay.
I can, yes, I can see him.
Okay. And can you tell what he's wearing?
Yes, he's wearing gray with black stripes.
Okay. Do you know that your brother is currently booked in the Kerr County Jail on 6 counts of human smuggling for a total of $300,000 bond?
Yes.
Okay. How old is your brother?
He is 21.
Okay. And prior to being booked and arrested on this charge, was he working?
Yes, he was working at Dave & Buster's as a buzzer.
As a what now? A busser?
As a buzzer, like cleaning
Okay.
tables.
About how many hours a week was he working?
Majority of the time, he was working about 16, which consisted of the weekend, since he was a full-time student.
Okay. And where was he a full-time student?
At Lone Star College, North Harris campus.
Okay. So as a busser, he was making approximately minimum wage in his job?
Yes, if I'm not mistaken, he was getting paid $12, $13 an hour.
Okay. Times 16 hours a week and times 4 hours, times 4 weeks a month. He was making approximately $1,000 a month, do you think?
Yes, give and take,
Okay.
yes, sir.
And prior to him being arrested, where was he living?
He was living with us at my parents' home.
Okay. And does he have his own home that he owns, your brother?
No.
Okay. Does he have any land or any property, real estate property?
No, sir.
Does he have multiple vehicles that he owns?
No, not that I'm aware of. The car that he was driving, I actually let him borrow for school purposes and work.
Okay. So aside from the money that he was making part-time at Dave & Buster's, does he have any other sources of income?
No, sir. Not that I'm aware of.
Okay. Is he able to afford a $300,000 bond?
No, sir.
Okay. Is your family going to be able to help him raise money for a bond?
Yes.
Okay. And about how much money can you and your family afford to raise for his bond?
As of right now, we have saved roughly about $5,000.
About $5,000. And at the $300,000 bond, as it stands right now, you're about $25,000 short. Would you agree with that?
Yes, sir.
Okay. Now, where was Jason living? Like, what was the city that Jason was living in before his arrest?
Jason is actually me.
I'm sorry, Anthony. What city was Anthony living in prior to his arrest?
Spring, Texas.
I'm sorry?
Spring, Texas.
And what
suburb
county?
Area of Houston.
Okay.
County is Harris County.
Harris County. And how long had he been living there?
So we've been in Harris County all of our lives. In Spring, we've been living in Spring all of our lives too. He was there for elementary, middle school, and high school.
Okay.
And college.
Where was he born?
He was born in Conroe, Texas.
Okay. So he's lived in Texas his entire life?
Yes, sir.
And in Spring, Texas, most of his life?
Yes, sir.
Okay. And besides working, you said he's also a student or was a student prior to being arrested?
Yes. He was supposed to go back for the spring semester and obtain his associate's degree in May of 2022.
Okay. And what was his plan after graduating in May of 2022 with his associates?
Get a full-time job under his degree.
Okay. And what type of degree would that be?
So he's getting an associate's of arts, if I'm correct, and he was in a tracking program for HVAC.
Okay.
So AC, refrigeration.
Okay. And where was he planning to look for a job and live after he graduated?
He was still planning on staying at home with my parents and save money and stuff. Mm-hmm.
Okay.
So he was still going to stay in the area.
Okay. Does he have ties and roots to the community where y'all live?
No.
Meaning he has.
What do you mean?
Meaning like he has a job and family and friends in the community in which y'all live?
Yes. Mm-hmm.
Okay.
Job and we have family that lives in the area.
Okay. And if bonded out, would he stay in that area?
Yes.
Okay. I'll pass the witness.
Were you aware that he left your home and came to the Kerrville area on December 21st in the car that you lent him?
No, sir.
Okay, and why weren't you aware of that if you're living with him and y'all are all under the same roof?
No, sir. I was not aware of any of that.
Okay, I know, I understand that, but my question to you is if y'all are all living under the same roof and being with each other in the same home, that he would drive across Texas to Kerrville, is that not something that you would know about or that would not come up?
No, because we don't really track each other on where we are. I mean, I have my personal life with my partner and I go visit him here in Katy. And so I'm in and out of the house. So his business, we're not really like involved other than education and work wise. So, and we don't know what time he left the house or anything like that.
Okay, but, and you were saying that that was your car that he was driving?
Yeah, so he has been having my car ever since he graduated high school to drive back and forward from college and go to work.
Okay.
But that's as far as the premises we're going. Mm-hmm.
Now, does he have any connections with people or places in Mexico?
No, sir.
Are you aware that a lot of the trafficking of human beings from Mexico involves the cartels?
Like, am I aware that like transferring people involve cartels?
Yes.
Yes, I mean, it comes up on the news.
Right. So do you know if he has any contact with the cartels of Mexico?
No, sir.
Okay.
No, sir.
Do you have any understanding as to how he became involved with the trafficking of humans?
No, sir, I do not.
Right. And again, you've stated that you're not really keeping up with his day-to-day activities.
Correct.
Okay. Were you aware that amongst the people that were in this vehicle that was transporting humans was a 14-year-old boy?
No, sir.
Okay. And I'm taking it that from your perspective, what you really know about what he was doing is going to school and working as the busboy at Dave & Buster's.
Yes, sir.
Right.
Mm-hmm.
So these allegations involving the human trafficking, if they are in fact true, then that's just, you had no idea. Didn't see that one coming, so to speak.
No, sir. Everything was very unexpected for us.
Okay. I pass the witness, Judge.
One last question, Jason. About how much you've saved $5,000 so far, about how much more can you realistically save, you and your family, for your brother's bond?
I mean, we can see if we can potentially accumulate another 5,000 by, working and asking family if they're able to help us out.
Okay. So at the most, you think 10,000 would be about the most you and your family could imagine coming up with?
Yes, sir.
All right, thank you. I'll pass.
No other questions, Judge.
Just from witnesses?
No, Your Honor.
State?
Just closing comments, Judge.
Okay. Mr. Rodriguez?
Your Honor, we're asking for a bond to be reduced to amount of $100,000 or less. You have a 21-year-old person who's been incarcerated, who is a student and who works only part-time, doesn't have any property or vehicles or real estate of his own, is relying on his family, basically financially, and his family essentially has been able to save up $5,000 and can maybe save up another $5,000 to get them up to 10. Mr. Alberto was born here in Texas, raised here in Texas, has roots to his community, lived in his community since childhood. He's not a flight risk, Your Honor. We're asking that $100,000 be the max for all of his bonds in order to ensure his presence in court.
Mr. Harpole?
Yes, sir, Judge. I would represent to the court that in this particular case, Your Honor, the defendant was the organizer of this event. The two individuals that were caught driving the trafficked people, when they were stopped, one of them gave up the phone number and his cell number for the defendant. And then the defendant was in fact in the area, and they posed as having gotten away and they needed to be picked up, and he drove over after they called and set up a meeting spot and picked up the person. So his involvement in this is not just as a minimal driver who was, gathered up to go down and pick these guys up. He's orchestrating and leading it, and in fact being all the way from Houston coming over here to oversee the operation and then pick someone up who got arrested by the police. We believe that the cartels are behind the trafficking, so there must be some association with that. So we believe that he is a potential flight risk. We believe that this is an egregious offense and that the bonds are appropriately set.
Thank you. Anything else, Mr. Rodriguez?
Yes, Your Honor. There hasn't been any evidence presented that I can see to support any of Mr. Harpold's allegations, Your Honor. Whereas I have presented evidence to you about the defendant's income and his ties to the community and the fact that he's not a flight risk. I would ask that Mr. Harpold's recitation of what he considers to be the facts not be used to determine what you're going to do, especially some of the more inflammatory things like the cartel must be behind this, because we don't have any evidence to suggest that, Your Honor. So asking for a $100,000 bond, I think that would be fair and appropriate under the circumstance.
Thank you. Court will reduce the bond to $25,000 per count with the mandatory condition of a GPS monitor immediately upon release.
Okay, Your Honor. I'll get you an order page for that. Should I just email it to you?
Email it to Christine and she'll get it to me.
All right, thank you, Judge. May I be
Thank you,
excused?
Mr. Rodriguez. You may.
All right.
Thank you.
All right, thank you. You can log off, Jason.
Thank you.
Oh, do we need a new date for Anthony? Before he's excused?
I think that if you've filed a waiver of indictment or that, when you do that, you'll get a scheduling order from the court if you wanted to go
Okay.
that route.
So we don't need a date right now. Okay.
Well, and let me tell you, if you're going to file a waiver, his next scheduled appearance would be February 28th.
Okay.
If you don't file a waiver, we'll see him on January 31st.
Okay. Thank you, Your Honor.
Sure.
You have a nice day.
Thank you. You too. Mr. Abel will be up next.
Okay, Judge.
Time to wake up, Miguel.
Yes, Your Honor.
How are you?
I'm doing well, Your Honor. How about yourself?
Peachy. Just waiting for the temperature to drop.
Awesome weather tonight, Your Honor. It's gonna be cold.
Yes, sir. How are you, Ed? Yeah. You got a blue pen? Okay. Here, slip it to me. Then. There you go. Can you get it? Okay. Mr. Abel?
Sir.
Okay. Court will call cause number B21-535. The state of Texas versus Hayden Abel III for purposes of an agreed plea. What say the parties?
State's ready.
The defense is ready, Your Honor. Just one last thing before we start with the plea, Your Honor. In the packet, we included a sex offender restriction. If the court will be willing to review that, I spoke with the DA and they're willing to go with whatever decision the court makes regarding that document.
Okay. Bear with me. I'm looking for the waiver of electronic appearance.
I believe it was not included, Your Honor. I apologize for the court. I heard it on the other plea and I believe we don't have it. I didn't include it, Your Honor.
I hate to say it, but I have to have it to proceed under the Supreme Court rules.
Yes, Your Honor. If we can, I don't know if we can do it verbally or if we can reschedule this plea for the next available court date.
Let's see.
The Friday's
Going to go now?
Friday's the next date.
Friday, we can do.
You want to do it Friday?
We can do Friday, Your Honor. I'll just go over there and I'll tell him and I'll have him sign it.
Okay, and when you go over there too, on the admonishments, the very first box, you need to check one or the other. It's not checked off either. So what I'm gonna do is give the paperwork back to the clerk, okay?
Yes, Your Honor.
All right, Mr. Abel, we'll see you Friday. Thank you. What do we have on Henderson?
Is Henderson next, Judge, or is it the female?
Yes, ma'am. No, it should be Henderson.
Thank you.
Uh-huh. Garrett, are y'all gonna do anything today on Mr. Henderson?
Well, Judge, I was going to talk to you about that. I just received that case from Mr. Wensky. I've made as much progress as I can on it in the couple days since I've had it. I saw Mr. Henderson this morning in jail. I'm not ready to go on the motion to proceed, Your Honor, but I do think that there's a chance that this can get resolved without having that hearing.
That works for me, Judge. If we can, we could reset it to February 23rd with the next contested docket day.
You want to do that?
Yes, Your Honor, that's fine.
Okay. And on the 23rd, we'll either run with it with something, whatever you've worked out, or we'll have a hearing, okay?
Yes, Judge.
Okay.
I don't know, Sandy. Don't drive fast.
How are you, Mr. Henderson?
You?
Good. It looks like you just picked up a new attorney with Mr. Cleveland.
Yes, sir.
So we're going to go ahead and reset your case for the next contested docket we have in order to give him time to investigate and fully explore your case with the DA's office, okay?
Yes, sir. Okay.
All right, you'll be hearing from Mr. Cleveland. We'll see you back then. Thank you.
Thank you.
What's the date, Judge?
February 23rd.
Thank you.
Thank you.
Sure. And do you want to stay with the guys or do you want to, does it matter or?
I can get Miss Howell. She's en route.
And while we're waiting on Miss Howell, who in the PDO's office picked up Jonathan Jones?
I'm not sure, Your Honor, but I can check.
That'll be me, Your Honor. Miguel
Okay,
Serrano.
great.
It's yours?
Yes, Your Honor.
Are you wanting to do anything today or are you just wanting to reset?
Your Honor, I just got the offer and it's not the DA's fault. It's not the DA's fault. So I would like to convey it to my, talk to my defendant, maybe come back on Friday. We're pretty close to an agreement. It's just a few
Okay.
years we're off.
Okay, let's take Mr. Jones and we'll move him to Friday's docket then.
So Judge, you're not gonna need Mr. Jones either?
We do not. We are going to need Miss Howell though, and she's got a suppression in at least one of these.
I don't see.
Cheryl, do you have motions in all three or just in one?
Oh, well, Judge, there's the motion to proceed on 748, and she's got a motion to suppress on 2020.
Oh, you know what? We lost her to the other court, didn't we?
Oh, right. She had a hearing at 1:30.
Yep. Okay. Jail's going to kill me.
Well, it's good to know that you're human.
Absolutely. Uh-huh. One on the 23rd, or you talking about this Friday? 8 a.m. Sure. All right, you're gonna hate me in the jail, but we just lost Miss Howell's attorney to another court, so we're gonna have to bring her back in a few minutes.
Okay, that's fine.
Sorry about that. So if we can jump to Clay Roberts.
Yes, sir.
Now, Judge, before they bring in Clay Roberts, I'd like to bring to the court's attention that the previous attorney for Mr. Roberts filed a motion to suppress on cause numbers B19528, and I think it meant to also do it on B19529 and B19909. Now, B19909 is a UUMV case, and after reviewing the case, I'd like to move to withdraw that motion to suppress on the UUMV case, cause number B19909.
Okay. As soon as I get the files, I'll make a docket entry on that. But you still have a suppression on 528 and 529, correct?
Yes, sir. I would like to go on those.
Just trying to confuse you. Got me too. Find suppression orders. Bear with me, Mr. Roberts. I'm trying to find your motion.
Happy New Year.
Thank you. You too. You know what date the motion to suppress was filed?
I can check, Your Honor.
Judge, I
Thank you.
see a file stamp copy of 11/8/21.
That will help. Thank you. There we go. I have any Post-it notes. I borrow one. Thank you. Thank you. Ready, Paul? Court will call cause number B19528 and 529, the state of Texas versus Clay Roberts. For purposes of a motion to suppress, what say the parties?
State's ready.
Defense is ready, Judge.
Okay, Mr. Cleveland, ball's in your court.
Yes, Your Honor. At this time, we'll call Officer John Mormon.
John, can you hear us? You're gonna have to unmute that computer.
Yes, sir, I'm here.
There we go. Can you please raise your right hand? In the matter before the court, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Can you please give your full name to the court reporter?
John Robert Mormon, Moorman. And I'm a
Thank you very
trooper
much.
with Texas Highway Patrol.
May proceed.
Thank you, Judge. Good afternoon, Officer Mormon. Thanks for being with us this afternoon. I appreciate your time. So on the night in question, on May 19th, 2019, you stopped a Mr. Clay Roberts. Is that correct?
Correct.
Okay. And after stopping him, you searched his person and his vehicle, correct?
Eventually, his person was searched, and yes, his vehicle was searched as well.
Okay. And you did that without a warrant, correct?
He was searched incident to arrest. His person was. His vehicle was searched, probable cause with the vehicle exception.
Right. And so without a warrant.
Correct.
Okay. Judge, I believe under State v. Ford, the burden is now switched to the state to prove that there was reasonable suspicion for the stop.
Judge, my only comment to that was there was no search of the defendant or his vehicle that led to the drugs in question that are made the subject of this. So the alleged search that he's complaining of was not, there was no search done by this officer of the defendant with regard to the contraband that was taken into custody.
And Judge, I'd say that there still needs to be reasonable suspicion for the stop. So I would then ask to be allowed to question Officer Mormon regarding his reasonable suspicion.
Mr. Harpole, do you want to address the reasonable suspicion or let Mr. Cleveland do it?
No, I'll go ahead and lead off, Judge. I don't mind at all.
Go ahead.
So Trooper, let's just start breaking it down a little bit, okay?
Yes, sir.
So on the 19th, why don't you just set up where you were patrolling, what area of Kirk County you were in at that time?
I was patrolling heading westbound on State Highway 39, just coming out of Ingram. When I passed Cedar Springs, I observed a white Jeep Cherokee waiting to make a left-hand turn. After I passed the vehicle and understand I was going slow, it's dark and there's a lot of deer out there. I observed the vehicle in my rearview mirror for quite some time, and the vehicle refused to pull out. It sat there and didn't pull out until I had actually started to go around the curve.
Okay, so let's just back up a little bit. So was he stopped at a stop sign or just stopped in traffic?
He was stopped at a stop sign on Cedar Springs.
Okay, and so you observed him stopping, and then as you passed by and then went on down the road, continue watching him. My understanding of what you're saying is that he wasn't making any movement at an area where he was stopped, that it would have been clear for him to proceed forward.
Correct. We were the only two vehicles on the road.
Okay, so that made you take note of the car as you testified, and then what happened next?
Well, as I said, that's not behavior that's consistent with the normal motoring public. So I thought perhaps that something may be wrong. So I turned around to try to get the license plate on the vehicle. The vehicle had rapidly accelerated eastbound on State Highway 39. When it got to Ingram Loop, it had made a left-hand turn and started up the residential road right there. I was at that time, I observed that the vehicle was traveling at a high rate of speed. I was able to get the vehicle speed with my front radar, and he was going 60 miles an hour.
And what was the posted speed limit for that area?
Speed limit in that area is going to be 30 or 35.
Okay, so he was exceeding the posted speed limit for that area by driving 60 miles an hour according to your radar.
Correct. And due to the shape of the roadway, he continued accelerating, and at one point his speed climbed to over 70 miles an hour.
Again, when it accelerated over to 70 miles an hour, had the police the speed limit changed to 70, or was that still above the speed limit?
That was still well above the speed limit.
Okay, what'd you do next?
Accelerated to attempt to catch up to the vehicle. As I approached Highway 27, I noticed that it turned a little left and then continued back across Highway 27.
What did that indicate to you when you saw that?
That the vehicle was attempting to evade me and avoid my having any interaction with me.
Okay, then what happened?
He pulled into the address is 3458 Junction Highway at the Town and Country Mobile Home Park. It continued past the mobile home park onto a property behind the mobile home park. The vehicle stopped suddenly, and then the driver quickly exited the vehicle.
Now, prior to that point, had you engaged your traffic stop lights or anything at that point?
Now, one of the things we're attempting to do is to catch up to the vehicle before we engage the lights, especially when he's traveling at those speeds. And it's apparent to me that he's attempting to evade me or avoid contact with me. I don't want him to be notified further back where he's going to really get on the accelerator and attempt to really run at high speeds because he's already got a large lead. So I'm trying to close the gap a little bit. Once we pulled into the trailer park, the lights were activated.
Okay, so, but the light, it sounds to me based upon your testimony that the lights were activated only after he came to a full stop and got out of the car?
Correct.
Okay. I pass the witness, Judge.
May I proceed, Your Honor?
You may.
Officer Mormon, on the night in question, you weren't stationary running radar, right? You were on patrol driving around?
Correct.
And specifically, you were driving as you testified on State Highway 39?
Correct.
And you saw the vehicle, the subject vehicle in this case, stopped on State Highway 39 at a stop sign on Cedar Springs Road, right?
Correct.
Now, according to you, as you drove by and after you drove by, that vehicle was stopped for too long, correct?
No, I stated that it hadn't moved. Generally, for normal motoring public, once the traffic that you're required to yield the right of way to has passed you and the roadway is clear, you go ahead and proceed. The vehicle in this case didn't do that. It just sat at the light as though, or what appeared to me that it was watching me until I got to the curve.
But being stopped at a stop sign isn't illegal, is it?
No, it is not.
Being stopped at a stop sign by itself isn't some sort of reliable indication of ongoing crime, is it?
No, it is not. Like I said, that's not consistent with the normal motoring public, however.
Now, it might not be consistent to your version of normal, but isn't it possible that somebody can be stopped at a stop sign to check their directions?
It's possible, yes.
Isn't it possible that somebody can be stopped at a stop sign for a few extra seconds to adjust their radio?
It's possible, yes.
Those aren't criminal activities, are they?
No, they are not.
Now, was it suspicious to you because you would recognize this vehicle?
No, I didn't really recognize the vehicle, and I didn't see anybody who was operating the vehicle. I just found the behavior of the vehicle at that time of night to be, like I said, outside the norms of the normal motoring public.
Now, right after in your offense report, you say that you observed the vehicle at the stop sign on Cedar Springs, waiting to turn onto State Highway 39. You state that it was a white Jeep Cherokee, right?
Correct.
Okay. Now, you recognize it because you had pulled that vehicle over in the past. Is that right?
I've pulled over several thousand vehicles. I couldn't recall one from the next.
Now, you had your dash cam video activated as you proceeded on in this case, correct?
I'm sorry, as I proceeded up 39?
Well, as you had your dash cam video recording while you conducted your business in this case, correct? With Mr. Roberts, the defendant?
Correct.
Okay. Now, do you remember in that dash cam video stating that you had pulled over the vehicle before?
Yes, I do recall that, and I believe it was his sister who had been driving.
Okay, and that would be a Miss Carrie Moulter.
It's in, can I look at my case report? I think it's in there. I believe the vehicle was registered to her, yes. And he'd stated that it was his sister's vehicle, which was Carrie Moulter.
So after seeing the vehicle turn on to State Highway 39, after it had been stopped for long enough for it to be suspicious, you turned around on State Highway 39 to follow it, right?
I turned around to get the license plate to, yes, follow it.
Specifically, in your offense report, you state that you turned around to check on the vehicle, correct?
Correct.
And were you going to stop the vehicle and check on the driver?
If there was a valid traffic violation, I would have stopped the vehicle, but I wanted to get the registration information.
Okay. But at this point, you indicated that you felt this vehicle appeared to be speeding, right?
When it turned onto Ingram Loop is when I noted that it was traveling above the posted speed limit.
Okay. And that was based on your radar gun, correct?
First, there was a visual observation that it was going too fast. We're trained to visually observe first, and then the speed was verified with radar.
And in fact, in your dash cam video, you know, from what we see from where it begins after you've already turned around, it's too far away to look at the registration, right?
Correct.
Okay. And you activated your front radar unit, correct?
Correct.
And you allegedly clocked the defendant at a higher rate of speed than the speed limit, right?
Correct.
And what brand is the radar unit that you have?
It's a Stalker Dual DSR, I believe.
Is that the model as well?
That's the Stalker is the radar, and then the model as well.
Gotcha. Were you driving your regularly assigned patrol vehicle?
I was driving my patrol vehicle. Yes, sir.
Did you test and calibrate the radar unit prior to your shift?
I verified that the radar was operating correctly. Yes, sir.
But you didn't indicate that in your offense report, did you?
No, sir.
How'd you test it?
We use tuning forks at the beginning and the end of each shift and then we also do a self-test after each traffic stop for if we're using the radar.
What are the speeds of the tuning forks?
I would have to get them out of my patrol car. I believe they're 40 and 25. There's going to be point something on each one.
Where do you keep the tuning forks in your vehicle?
Tuning forks are in my driver's side door pocket.
Okay. Are they in a case or just in there?
They're wrapped in a plastic case or in a Ziploc bag.
In a Ziploc bag, not a hard case or anything?
No, sir.
Okay. Do you know when they were last certified?
I actually have that down in my car, and I want to say it was, I believe it was I think it was 2020 or 2021.
How about prior to this stop in 2019?
I would have to go look. I don't know.
Okay. Now, for the radar to work properly, you have to have the subject vehicle in your line of sight, correct? In the line of sight of the radar, I should say.
Yes, the radar has to be able to pick it up.
And hills and curves in the road can disrupt that line of sight, correct?
Yes, I mean, if it's around a curve and you can't see it, then yes.
And there are plenty of hills and curves that we can see in your dash cam footage, correct, on that road?
Correct.
And your reason for pulling him over was the alleged speeding, correct?
Yes, sir.
But in your offense report, you state that the reason for the stop was expired tags and registration, right?
He also had expired tags and registration, and he also had that's in addition to along with the speed.
But you couldn't see those tags and registration in the dark behind him, right?
Not till he came to a stop.
And expired tags and registration isn't why you turned around on 39 to check on him, right?
No, sir.
Judge, we'll pass the witness.
Just briefly on the in the aftermath of the stop, I'm just gonna, as far as the arrest of the defendant, did you arrest him on that occasion?
Yes, sir, I did.
And why was that?
Possession of methamphetamine and tampering with evidence.
Okay. And the methamphetamine that you found was not the result of a search of his body or his vehicle?
No, it was not.
Okay. I have no further questions, Judge.
Cleveland,
Nothing further, Your Honor. Just closing.
may this witness be excused?
He may, Your Honor.
Yes, Your Honor.
Thank you, John.
Thank you, Judge.
Closing argument?
Yes, Your Honor. We'll close with that. Under Terry v. Ohio, the first prong of a reasonable stop is that the officer's action must be justified at its inception. At its inception, there need to be articulable facts that the defendant has been or will be involved in criminal activity. Now, we'd argue, Your Honor, that the inception of this transaction is in no way justified. Officer Mormon turned his squad car around on State Highway 39 to begin to follow a vehicle, check on a vehicle that not only did nothing illegal, but followed the law too well for stopping at a stop sign too long. And he admitted in his testimony that there's a variety of reasons that people can be at a stop sign for long enough to allegedly cause suspicion. Now, stopping at a stop sign for too long is in no way a nexus to reasonable suspicion that a person is involved or is going to be involved in criminal activity. And in Bland v. State, Your Honor, the Texas Court of Appeals for the 13th District held that a driver who stopped at a stop sign slightly into the intersection did not give rise to reasonable suspicion. It should remain the same with a driver that stops at a stop sign for too long. If the beginning of this transaction is a justified inception of a stop, then every American that takes extra caution in front of a peace officer could inadvertently give rise to some sort of suspicion, some sort of scenario in which they can be followed and watched. Now, if you find, Judge, that the inception of this encounter is valid, or that the inception of the stop occurs at the alleged speeding, we would argue that the facts are not articulable enough to rise to reasonable suspicion there. In the video, or excuse me, in the officer's testimony, he says that he's fairly far behind the defendant by the time he turns around on State Highway 39. He states that there are curves and hills on that route that can present obstacles to his radar gun, which we can't confidently say is calibrated correctly. We don't know when the tuning forks used to calibrate it were last verified. Further, Officer Mormon does not allege speeding as the reason for the stop in his own offense report. He states it was expired tags and registration. And he told us today, Honor, that he wasn't close enough to see that in the dark behind the defendant until the defendant was stopped. Now, facts that were articulable for reasonable suspicion after the stop don't count in this case. It has to be before the stop. So we'd ask, Your Honor, that any evidence and statements made after the stop be suppressed because the stop was invalid for the reasons stated.
Thank you, Mr. Cleveland. Mr. Harpole?
Well, at the onset, Judge, I would just point out that the officer did not formally stop him. The defendant stopped on his own accord when he pulled up to the residence that he stopped at. And his officer's testimony was it was only then that the officer stopped and illuminated his vehicle with his lights. But besides that, he had reasonable suspicion based upon the speeding that he observed on 2 occasions, the initial over the speed limit and then the second speed limit, which justified the stop. So this is a good work by a police officer, and his testimony is true and accurate.
Anything else, gentlemen?
No, sir.
No, Your Honor.
Okay. Court's going to deny the motions to suppress. What else do we have?
That's all for me, Judge.
Nothing from the state, Your Honor.
Will Mr. Roberts be at pretrial in 2 weeks, or are we skipping to the next one, or what are we doing?
I will have to confer with my client, Your Honor, and decide if we want to be at the next one or skip on the road.
All right, fair enough. Thank you, Mr. Roberts.
Thank you.
Thank you. I didn't see one. It's my docket. Sure. And we'll see who they bring next. Whether we go back to Hal or down to Wesch.
Judge, if I'm not mistaken, that was the only business I had in front of the court this afternoon. So may I be excused?
Absolutely. Have a wonderful evening. Thank you.
Thank you, Your Honor. You as well.
Thank you. Who are we bringing out?
This is Mr. Wesch,
Okay. And Mr. Wesch's office.
unless you need that female judge.
No, it's all good. We're good. We're good either direction.
Okay,
We were guessing which way you were gonna go.
who won? Okay, have a seat.
Bob, what are we hearing today? You're muted.
Judge, I'm not sure if the jail could have Miss Howell call me, then I wouldn't need a breakout room with her. I don't know if that's possible,
We can do that, Judge.
but that
Okay.
would save time hopefully in the docket.
Cheryl,
Thank you, Cheryl.
would you mind giving me your phone number?
830-997-4663.
Okay, I will have her call you.
Thank you so much.
Here's the forms.
Ready, Bob?
We're ready, Your Honor.
Court will call cause number B19-819, the state of Texas versus Shane Otto Wesch. For purposes of a motions hearing, let's say the parties.
State's ready.
Defendant's ready, Your Honor.
All right, what motion are we addressing today, Mr. Calvan?
Your Honor, it's defendant's motion to compel Zoom testimony. That testimony would be our witness, the Liberty Mutual claims adjuster, Miss Flazewski. I'm probably mispronouncing that, but the spelling is FLESZEWSKI.
All right, you may proceed.
Yes, sir. This is a witness that we have been aware of since almost the beginning of this matter. She became involved before I was even retained, I believe. But after interviewing her, as I presented my motion, she presented me, I received evidence that I believe is exculpatory to Mr. Wesch, in addition to being impeachment evidence as to the state's complainant, Amanda Ginsman. At that beginning, I did notice the state that we had such a witness, and but without naming, without providing any contact detail, but I felt like, when I did so, there was no, interest in the on the state side in contacting her regardless. However, I believe it's been a year. I believe it was December 2020 when we did file our motion to dismiss based on constitutional grounds, in which I will reiterate, as I did then, was a valid motion based on a valid legal principle that I presented in the context of a treatise that I cited to, and also presented a case. We went nowhere with that motion, understanding that the state, determined that it wasn't a valid motion on their part. But I still disagree with that. However, that is in the past. But in that instance, our first attempted hearing on that motion resulted in a continuance because this claims adjuster could not be there for reasons that I believe we presented, and I filed a motion to continue. Under the code, it was required that I present the substance of her expected testimony, and also an affidavit, indicating that this was, the substance of her testimony. I needed to do that under the code, and also that her testimony would be critical to Mr. Wesch and exculpatory and, impeaching the state's complainant, Ms. Ginsman. We also provided all of the claims adjuster, all of her contact information. So state's been in possession of all that, and I received that through emails with her, including phone number and her email address. Now, what the court didn't see was the cadre of Liberty Mutual attorneys that I had to wade through just to get her into that, into a position where she would testify. So that was extremely difficult and a lot of pushback on their part because they're used to dealing with civil proceedings and not criminal. But ultimately, they gave me a what they call a field attorney in San Antonio at the time to be a part of the next hearing and to advise Ms. Flazewski on, how things were going to proceed. On the next hearing, that was the instance where we had some sort of a faux pas where, they insisted that they were in the waiting room. You indicated that you couldn't find them. So for that reason, we lost her testimony, but the court and the state saw the substance of what we would have to offer if we were proceeding to trial and if we proceeded with that particular motion. So the state has been in possession also of our, expected, Ms. Flazewski's expected testimony, which we would offer in the context of a trial under Texas Rule of Evidence 613, which would be, after laying the, predicate, which we would just offer in the event that after my direct examination, Ms. Ginsman, if she denied any of that evidence or any of those statements that we are saying that she made to the claims adjuster, then we could present the evidence. We present the substance of the claims adjuster's interviews and the information that she received from Ms. Ginsman in the context of those interviews. So my point is, all of us are, we all know what that information is going to be. We know what she's going to say. Now, I always understand that the state always has a fair opportunity to argue that something about that testimony, is inadequate, or they have a new witness, or they want to compare it to what they feel happened. And I understand that. State has never reached out to me to present that, never offered me another witness that they think may have that would support their theory if it is. And we've never had the state offer what their theory might be to abrogate anything that this claims adjuster might say. So in that context, we, proceeding to trial, in good faith, I had to deal with the Liberty Mutual attorneys. Ultimately, they agreed that we had a right to subpoena her and bring her in, and we did it, and we expected to bring her here in the flesh. We had everything set up, subpoenaed her. The Wesch family had to borrow money to pay for transportation, including airfare to San Antonio, a rental car, a room, and expense money while she might be here. And I had anticipated it might be even 4 or 5 days because I wouldn't know where things may go. So we really made a good faith effort to get her here in the flesh. But as I pointed out to the court, I believe on the 13th, I pointed out to the court that on December the 9th, that she sent me an email, which I attached to this motion, where she told me she wasn't going to come. I mean, and I can tell you there's not going to be any way that we're going to get her here in the flesh. And it's not just going to be us dealing with a witness somewhere out of state that has no support. We are going to be going up against the Liberty Mutual attorneys that are dead set on supporting her position that she shouldn't be made to come here particularly in the time of the COVID virus. She's also informed me that she has 3 children. She can't afford to have someone sit around and care for them while she might be gone. And most importantly, on her part, that she couldn't afford to expose herself, in the context of a travel to the state of Texas, airfare, by airplane, in the terminals, that she would have to deal with, or in the context of the trial itself, anybody she might have to be in contact with while she's at the hotel. She said, I made the effort. I've since then been communicating with a representative of the legal department who's just hanging there waiting to see where we might go with this. Now, for that reason, I filed this motion. I presented it to the court. I knew we had a very limited time space. I did get that motion. It did come in the morning of the 9th early, but I left earlier to get to Gillespie County, got back late, so I didn't even see it really until the next morning. That's when I created this motion. It was on a Friday, but at the first available chance in person in the court, I presented that motion to you and to the state. And I really feel like in good faith, everybody should have understood that given the scheduling of our trial, that we needed to resolve that thing really on that day. And I didn't really, honestly, I was surprised that there was any resistance to it because it was such a reasonable request. And all of us know what we're dealing with the COVID. Also, in the context of my motion, I presented our Supreme Court the 45th emergency order that, based on my interpretation, allows for us to bring in this claims adjuster's testimony through Zoom. I've heard nothing from the state, how they might be prejudiced having her testify by Zoom. I've seen nothing that would justify the state claiming that their position might be in good faith, but I'm willing to listen. But I cannot see how her testifying by Zoom would in any way prejudice the state's position. In addition to which, and I remain very, very concerned that given the fact that we made a very good faith effort to provide the state with all of the information, contact information of this person, that nobody, as far as I know to date, has reached out to contact her and interview her. We would have, we couldn't stop the state from doing it, and I would very much appreciate the state's, efforts to do so. I know that they've interviewed Mr. Wesch's girlfriend, they've interviewed his father, making those efforts. This would be, a telephone call to a lady who was very nice. And I think her position is valid. But we're not going to get her here in the flesh. It's been, hard on me, but extremely hard on Mr. Wesch. He's been, locked up for 2 years. We thought we were going to have our trial, and Your Honor, I didn't hold it against the court or Mr. Harpold, when we had to continue that. And I'm going to say that, I was a little concerned that nobody asked me about it, and I couldn't have argued against you because I understood the schedule you were dealing with, and we did check with Miss McIntyre, and we knew there weren't going to be any court proceedings, and sometimes that stuff just happens. And I think, everything, we would have had to continue it anyway. I do think that it's something that, it was my motion, and I would have appreciated that the court and Mr. Harpold reached out to me to discuss it before there was any movement to continue. If for no other reason, just so we could talk about, the date that we would continue to, because it was continued to February 1st, and that's created, a problem with us, and we cannot get out of our hearing that we have in the 452nd. And
let me address that real quick.
Yes, sir.
The court continued that on its own motion, frankly, because your motion was late filed. There was no court in session between the time your motion was filed in the trial, and there was no time to address your motion. And your motion indicated that this was an essential witness. So it was continued to allow you to address this problem.
Yes, sir.
Not to try to prejudice you, but to try to give you the opportunity to address the witness issue.
Yes, sir. With respect, I did not feel like you were trying to prejudice me or Mr. Wesch or our efforts. My point was only that, you know, maybe I'm old school. I just wanted to be included in the discussion, but I understood where you were, Judge. I wasn't the only person picking at you at, you know, with this schedule, with this coming up. That was all fine with me. You know, we can't do this on the first, but we are going to file a motion to continue, and I have no problem with what you did and continuing it the way you did. Other than it's just something that, you know, I like to kind of be in on the discussions, just to hear what's said and say, you know, make my, you know, offer what I had to say. But I don't think that there was any conversation that we could have had that could have changed the circumstances and put you in a position where you could, you know, somehow salvage anything and give us our trial right there at the beginning of the new year. So I have no problem with that. The point is, I'm just trying to present to the court that we've already been through this. It's been very frustrating and a killer issue for Mr. Wesch. And in light of all of that, in light of the fact that we've heard nothing that, you know, from the state that somehow letting her testify by Zoom would create a problem. And I think that before the state would object, and since it had the opportunity so long ago to talk to her, that it would have talked to her. And if that raised issues why they felt like she might be, you know, her testimony might be, you know, prejudicial to the state's position, that they dealt with that now so that we could be coming in here and they could present some kind of argument other than I object, because that's all I see. We object. And the extent of her testimony, and I can tell you right now, I doubt that she has any great personal memory of all of our discussions, but I interviewed her on multiple occasions. But I did memorialize, you know, her expected testimony and her motion to continue. And she and her attorney, Liberty Mutual attorney, her name is Laura Holder, they, without me being present, they reviewed it and created that affidavit where she agreed that, you know, what I put in that motion to continue. They actually went through and modified what I put in there. And I told them, here, this is what we're going to say. If there's any issue and you want to change anything, change it so I can get this filed. And that's what they did. I played no part in what they came up with in that affidavit, which attests to the truth and veracity of the statements that, you know, I got from this Plea in the context of our interviews. So, and all of this is, we're not talking about bringing in a witness who is going to come in and say that Ms. Ginsman is lying. She's not, she wasn't a witness to what happened. All she can do is present the substance of her interviews with Ms. Ginsman in the event of wherein, you know, in the context of my cross-examine or direct examination of Ms. Ginsman, however that may come up under Rule 613, that, you know, I can go over those statements that are, you know, that information that I got from the claims adjuster, present it to Ms. Ginsman. And in the event that she denies any of that, you know, any one of them, then I can put on the claims adjuster to present what she did get from Ms. Ginsman to impeach what Ms. Ginsman says. And that's a valid methodology under 613. That's, you know, lay the predicate, present the information to Ms. Ginsman and let her, you know, deny it or agree to it. And that goes to the jury, and it's their choice to believe the claims adjuster or to believe Ms. Ginsman. But all that said, you know, I believe that, you know, we're, you know, all things considered, and particularly under the, you know, current circumstances. I mean, if this COVID stuff is going to be a problem, you know, and it seems to be getting worse, on all the areas I work in. About right now, it's about 12 jurisdictions, not getting any better. I fear that it is going to be getting worse. And, I'm going to be, fighting the Liberty Mutual attorneys and, they may somehow drag the court in. I mean, I can't tell you they won't, but they're upset. And I don't, I have to agree with them. I'm very, very sympathetic, and I completely agree with Mr. Koziski that we shouldn't have to bring her in here in person. And I've seen nothing from the state that would justify denying that request, particularly in the face of this emergency order, the 45th emergency order. I did look at this document that Mr. Harpold sent, and I looked at it. This section regarding criminal cases, and that refers to remote jury proceedings being remote jury trials. In other words, if either side objects in a trial where the defendant may get jail time, then the court can't hold a jury trial by remote testimony. But there's nothing in this document that I just referred to, the 45th emergency order, that would preclude a witness testifying, through Zoom or, any other methodology where we can get to remote testimony. So that's my position now. I present this, let the state make their statement, and I'd like an opportunity to respond.
Thank you, Mr. Galvan. Mr. Harpold?
Judge, just real briefly, I think it's worth the courts just knowing this, that in Mr. Galvan's recitation of all the background facts leading up to this, and speaking of the motion to dismiss that was filed and the ruling by, as he said, the state, which the state did not make the ruling, the court did. I think the court should be aware that in the aftermath of the court's ruling denying his motion, Mr. Galvan filed a former grievance against me personally with the state bar with regard to the outcome of that and prosecuting this case. So to the extent that his take on things and the way he views this case, I just completely and wholly disagree with everything that he's saying. I don't believe this witness has any credible information. I don't believe this witness is a credible witness. I believe this is just a fantasy that he has crafted to do whatever he wants to do in his trial. And if he can get her here, fine. And if he can't, that's just the way it goes. What I provided to the court was the update from in the court's emergency orders. And it does say, and the court will note that the indictment alleges 2 enhancement paragraphs. So the defendant is looking at a minimum of 25 years if convicted. So obviously we all know that the 25-year minimum means that there's no chance of probation or anything. So it is a confinement case. And that in criminal cases where confinement in jail, and Judge, I don't know if you have that in front of you, but it's in the middle of the page, the 1, 2, 3, 4th dot paragraph down.
I have it. Thank you.
Okay. In criminal cases where confinement in jail or prison is potential punishment, which of course it is since he's a habitual, remote jury proceedings must not be conducted over the objection of the defendant or the prosecutor. Remote jury proceedings would include anybody participating remotely, which would be Zoom, which is the whole point of the recent updates in the order with regard to Zoom hearings and people participating by Zoom and whatnot. So I have stated before that I object. My previous objections were also including, that's what I was getting to, is that it's a relevant witness. But nonetheless, I'm objecting to the court forcing me by motion of defendant to allow a witness to testify via Zoom. And so I'm objecting to that. I have the right to object to that. And that I need to offer Mr. Galvan an explanation as to why I'm objecting. Well, I've already said it previously before. It's irrelevant. The whole thing's irrelevant. She's irrelevant, has no bearing, and it's a waste of the court's time. So that's my position. But I don't have to provide that according to the update. I can just object.
Thank you, Mr. Harpo.
Your Honor,
Brief response?
I hope I can make this brief, but it's, a lot larger than I would have made since I want to address my grievance. Because, I'm not offended, but I can tell you I made every attempt, and I don't know whether the court's seen that grievance. Mr. Harpold is, but, and I can tell you when I first filed that grievance, I didn't even include Mr. Harpold's name. There's nothing in that grievance, if you would read it, that would indicate that I was in any way trying to take a personal shot at Mr. Harpold. What I was
Well, you
doing,
did, and it was taken that way, Bob.
Excuse me,
So
let me finish, Steve. And I understand. I know you're offended, and I wish
Well,
you.
and let me clarify that anytime any attorney has a grievance filed on them with the state bar, the court has no knowledge that a grievance is even filed, let alone what the substance is, unless the bar actually finds it to be a sanctionable offense. We don't have a clue.
I appreciate that. It has been made an issue in this hearing, and in relation to somehow making it relevant to my motion to allow this claims adjuster to testify by Zoom. So I'm going to say this again. I reviewed 3.09 under our rules, disciplinary rules, and I understood 3.09. And the substance of it is that prosecutors shouldn't proceed in a matter where there was no probable cause for doing so. I would agree at the beginning that there was probable cause, and because we had nothing more to go on than this offense report, and I have no problem with them feeling that they had a right to file their charges, because I would agree that they certainly did. However, in the progression of this matter, we came up with this claims adjuster's testimony, and I'm going to just address the shots that Mr. Harpo took against that in a minute. But then we also had the testimony of the investigating officer, and who I didn't get into too much, but he got the facts. He's the one who agreed that based on the damage to the vehicles, that they were facing in the same direction. And, based on my understanding and my knowledge of the matter, that's exactly what they were. I even understood now, the innocence of why Mr. Wesch was even there to begin with, but we can get into that later if we have to. But the point is, even the officer claimed doubts. I mean, my reading from the testimony, that what Ms. Ginsman said made any sense. All of that together, just as an individual sitting from the outside, if I was sitting on the outside, I would go, well, that's the end of that case. I felt like when we presented the evidence we had from the claims adjuster, that was enough to negate probable cause. Probable cause is just a reasonable belief that the defendant did what the state said they did. I think they may have had it at the beginning, and I agree they did, but after this evidence came in, I just did not believe it did. And this wasn't something where I was trying to take a shot at the state. I first filed that, and it's extremely neutral. I did nothing more than to present the facts, and I wanted nothing more than the bar to step in and tell us whether or not they felt like there was probable cause. They had to call me to tell me that I had to include Mr. Harpold's name. But even in that context, and Mr. Harpold can go back over that grievance and look and show it to his friends, I never took a shot at him. And I never felt like I had a reason to, on a personal level or even on a professional level. I strictly wanted a review of where we were, because I had a guy that I knew was innocent. He was in jail. and had already been there for quite some time. And so, I apologize, Mr. Harpold, for, feeling like it was a personal shot, but it absolutely was not. It was a completely neutral document. And even after I had to add his name, you can look at it, and I made great lengths to never say anything in there. I did nothing more than to present the chronology of my investigation, what I turned up, and then what came out during that hearing on the motion to dismiss, and ask them to consider whether 3.09 applied or not. I did have a conversation with the bar attorney that was looking at it, who informed me that he felt, all things considered, that it was premature, and it was something that we were just going to have to if we felt like we had to after the trial, that then they would look at it, and so I dropped it. So that's our grievance. No personal shots, no personal shot men. It had, and I can tell you too, if Mr. Wesch had not been in jail, I wouldn't even have done that. I'd been happy to proceed to trial and try the thing. But I represent Mr. Wesch, and I don't represent the state. I can't, in this instance, I can't, try and be the good, go along and get along guy. It hurts me that, I have damaged my reputation with the state, and we can't even talk now. I mean, I'm willing to, but I can feel the energy, and I understand, and I'm sorry about that. But we're the professionals, and we all get to go home at night. Mr. Wesch doesn't. So that's where we should start when we're looking at, whether we feel like we ought to be offended about anything that's happened in this matter. Now, that said, I do take great offense to Mr. Harpold's representation of this claims adjuster. She's just out there doing her job. It's a fantasy. It's not credible. It means nothing. I'm going to ask the court to let Mr. Harpold, you can't just make those statements and say she's not credible. It's a fantasy. Nothing she says, we believe. If that's how he feels, and the importance of this motion is so great, then he really needs to go over every one of those issues and tell us why it's a fantasy and why her testimony would be not credible. I think there's every reason to believe that it's very credible. It's certainly more credible than Ms. Ginsman's. She's just out there doing her job. When Ms. Ginsman called her, this claims adjuster didn't know anything about any criminal matter. She was just listening to Ms. Ginsman make a claim. That's it. She wasn't taking any personal shots, and there's nothing, fantasy about that. She collected information from Ms. Ginsman, and I got that from her from our interviews. She presented me her notes, which are scant, but there are elements in there which are also damning to Ms. Ginsman. And all of that, would need to be presented to the jury. And standing up and saying we just reject because it's a fantasy, I mean, that is offensive, and it's wholly inadequate. This is a really important matter. No, we cannot proceed to trial without her. I disagree with the state telling us that allowing for Ms. Flazewski to testify by Zoom is prohibited under the 45th emergency order, and I included the 45th emergency order in the context of my motion. Number 3, subject to any constitutional limitations and review for abuse of discretion, all courts in Texas may, in any case, civil or criminal, without a participant's consent, allow or require anyone in any hearing, deposition or other proceeding of any kind. I'm going to shut the door on him when you get him back. Sorry. Hey, think number 3 in the 45th emergency order, if you look at section 3 in the center, that, you know, the testimony from this claims adjuster can be brought in, you know, it says here to participate remotely, such as by teleconferencing, video conferencing, or other means. I believe that this section number 3 relates to jury trials. And I think that was clarified because I know that there were numerous writs filed, you know, by the defense bar, you know, and other courts where they complained about anybody trying to proceed or force them to proceed remotely on a jury trial. But I do believe that it would allow, it really demands the courts to allow, in this particular circumstances that I've outlined, to allow this claims adjuster to communicate remotely. Now, I did, this morning, I got a copy of this document that you have before you. It came from the state. I read it and I looked at the bottom, and there is a website, or, you know, it's an email address. And, you know, we immediately sent out a question asking them if that, you know, relates to jury trials only, or to any participant in those trials to testify remotely. We haven't got an answer yet. But if the state wants to rely on that, then I'm going to ask the court to allow us to, you know, get that answer. The state's the one that submitted this document. The state's the one that's made that argument, which it has a right to do. But we'd like to get a response from, you know, whoever it is that's going to be answering our question. And it did go to a email that they provided. They asked us to, if we had any questions, to, you know, send them to that email. So we're still waiting for a response. But I'd ask the court to let Mr. Harper, I mean, give him all the time he wants to tell us why she is somehow non-credible in the face of his witness, his complainant, Ms. Ginsburg. How is this person non-credible when all this information she got, there was no knowledge that there was even any kind of a criminal proceeding going on? She did not know that until I called her. So why is she not credible?
Let me ask you a quick question. Has there been a prior evidentiary hearing on this case?
Prior what?
Prior evidentiary hearing where there was discussion of the vehicles and
we did
interacted.
Yes, sir. In that at that motion to dismiss hearing, we did, you know, we tried to bring in her. I mean, they were set up. I mean, I can tell you they were incensed that you know, they didn't get to testify. It was a bummer. Not at me, Judge. You know, they blamed it on me. I sucked it up. But and it took me months to get them to start talking to me again. And right now I have a single individual that I'm, you know, just emailing with. I still haven't even got a phone number to talk to one of them. But we did have that hearing and that motion. I believe it's been about a year ago. And we did get a lot of testimony from the investigating officer.
Okay, that's what I was thinking. I was just trying to make sure I was thinking of the same case. So
yes, sir. What it was when I first got the office report, you know, and I looked at it, and I had, you know, interviewed Mr. Wesch, and I looked at it and I went, well, based on what she's saying, I don't know how she could have driven at it. That was what I did pose that to this claims adjuster, and as I said in my motion, she said, well, that was one of, you know, my initial problem too, also. But when I kept questioning her, she gave me, you know, 2 or 3 different versions of how it happened, including one where she was sitting behind her car. She said it just became so nonsensical. She had plenty of opportunity.
Let me stop you real quick.
Yes, sir.
Mr. Harpold, do you have any response or anything else you want to add?
I'm not going to respond to disclosing my thoughts about witnesses and trial strategy, so I have nothing else to respond to, Judge.
Your Honor, no fair. He has already. He said that, you know, his argument is that this witness that we are asking the court to allow testify by Zoom it seems that the substance, the basis for his objection is that she's non-credible and that what she has to say is a fantasy.
Okay, here's what I'm gonna do. I'm gonna take the motion under advisement. And I'll sit on it until Friday, and let's see if you get a response from the Office of Court Administration, because I think that's who's answering those emails.
Yes, sir.
Okay. And then one way or another, I'll rule Friday either with or without a response.
Sounds great to me, Judge.
What else do we have, gentlemen?
Judge, just quick housekeeping. I'm not sure if Mr. Galvan has ever made an election as to punishment. And so I just want to remind him that that's something he'll need to do prior to trial pursuant to 2801. And then secondly, he's made no attempts at plea bargaining. And I just want to make sure that the defendant is aware that the state's offer is 35 years TDC.
I've been over all of that with Mr. Wesch.
Okay.
I have, unlike the state, have investigated this thing fully.
Oh, Bob, trust me, I've investigated it, and we'll find out how that goes when he goes to trial. Okay.
Your Honor, I feel like I'm asking.
Hang on, y'all stop.
Yes, sir.
If you're going to file a motion for continuance, I would respectfully ask you to please file it immediately.
Yes, sir, I will.
Because it'll affect what the court does.
Yes, sir. But given the fact that you're going to make a decision on Friday, if it is against us, then I believe, for purposes of review on appeal, that the state has to now provide its reason, something more than fantasy and non-credible.
I also said irrelevant.
Or irrelevant. So for each one of those items, we're asking the court to require the state, rather than just sitting there and make this, objection really based on hot air. Okay, define the basis for that objection in legal terms and for legal reasons, legal principles, not fantasy, non-credible, or irrelevant. If they say irrelevant, then why is it irrelevant and how can it be? And without me saying it, with the state saying it, because that needs to come under review. And Your Honor, I feel like you need to hear it too. Otherwise, if you deny us, it's going to be because Mr. Harple said it's a fantasy.
Okay, let me know what you find out from the Office of Court Administration.
Yes, sir.
And as soon as I receive that communication, if it's before Friday, then I'll rule. And if I don't get it by Friday morning, then I'll rule. So
Yes,
that
sir.
everybody knows and you're not hanging on the edge. Otherwise, as it stands right now, it looks like our next scheduled pretrial is on January 31st, and I think we're set for trial February 1st, if I'm not mistaken.
Yes, sir. If I may just address that real quick, and with all due respect to the court, and I understood why you made the decision to continue. I do feel like that procedure that the court went through. I found no validation for that under the chapter dealing with continuances. I believe it had to be, the court's decision needed to be predicated, after allowing both sides.
Okay, let me just clarify it. I wasn't going to say this, but let me just clarify it. I continued it on the court's own authority because if I would not have continued it, your client would have had an ineffective assistance claim after the fact if he were found guilty. So I continued it to give you an opportunity to address the issue.
Yes, sir. My point is just procedurally, I don't know that's just, yes, Your Honor. I don't want to grind on that, but we do need this thing continued.
Okay.
So we'll file our continuance and we'll do it quickly.
Okay.
Yes, sir. I will say that we did reach out to Mr. Harple quite some time ago, for an agreed to order. We presented all the dates that we would be available to try this case. And I can tell you that even though and I respect it to be a hardship on everybody to have to prepare during our holidays, and I wasn't thrilled about it, but we were ready to do so. But that said, I'll get my continuance together and present it to the court to Mr. Harpo.
Okay.
Yes, sir.
Thank you. Mr. Wesch, we'll see you at the next hearing. Thank you.
Thank you.
Judge, did Miss Sione decide she needed to see your client?
I don't know. Cheryl?
Judge Cheryl and I have been able to confer, and she was able to talk with her. I'm sorry, Cheryl, I just jumped in while you were muted. We have reached an agreement and resolution to this case, and I don't think they need to bring out the client. And Cheryl, if you can do the plea on Friday, we can get the paperwork ready. But if not, we can just pick another day.
I would say best to pick another day. I know I've had lots of times where I've had stuff going on. I have a mediation set for Friday.
Yeah.
And I'm not sure whether that's in person or via Zoom. So I just don't want to delay the court.
Would
Or
February
ask to be first.
would February 4th work for you?
The morning of February 4th is great.
Okay, 8 a.m. February 4th. Is that okay with you, Judge?
That's just peachy. We'll see everybody back on February 4th.
Okay, thank you very much.
And I'll provide that date to her.
Okay, and what about our officer who's been patiently waiting in the law library all afternoon?
In light of reaching an agreement, we won't be proceeding on our motion to suppress.
Okay, I can be excused.
Yes.
You can, but you look good on camera for what it's
Thank you,
worth.
Judge.
You're welcome.
I apologize for taking up your afternoon.
Not a problem, man.
Okay. Stephen, do we have anything else left to address?
Judge, I think that's it. Thanks for everything.
You're more than welcome. Miguel, do you have anything else or are we good?
No, Your Honor, we're good.
All right. Y'all have a good afternoon. Thank
Okay,
you.
thank you. You too. Bye-bye.